A lot of people don't know who we are, what we do. So just a quick overview, we're lead org of the National ERA Coalition. We're nonpartisan and nonprofit, been involved or weren't incorporated, but we were formed in 2016. We have 13 North Carolina-based lead organizations, which you see on the right. And we have one mission, and that's to ratify the ERA in North Carolina and in the US Constitution. We do this by grassroots speaking, local government resolutions, and of course, state actions with ratification bills in the NCGA. So you look at this, and I'm going to give you a little context here. A 2020 Pew Research study found that the majority, 78%, of Americans favor adding the ERA to the Constitution. And the text of the ERA is really simple. And remember, when the framers of the Constitution crafted this back in 1787, they purposely left out two groups of Americans, African Americans and women. The 13th, 14th, and 15th Amendment attempted to rectify that problem for Black men, but it took another 52 years for women to even have the vote. So kind of an overview of the timeline for the ERA. So it was first introduced back in 1923 by the great suffragist Alice Paul. And this means we've been fighting to have the ERA added to the Constitution for 98 years. In 1972, the amendment passed both houses of Congress bipartisan and was sent to the states for ratification. Things were going along pretty good, and by 1982, we actually finally got 35 of the required 38 states ratified. And sadly, that was it. The time limit was over. So a new ERA has been introduced in every Congress since 1983. Now, the first three-state strategy, which was this idea that if we get three more states, the ERA will be ratified, was first introduced in 1984. But what got people fired up was when the Madison Amendment, which is the 27th, passed after 203 years. In 2011, the US House drafted a bill to remove the time limit, and in 2012, the Senate did the same. In 2020, the House approved the resolution to remove the time limit for the ERA, and it really reflected not only its judgment that the time limit is not immutable, but also its recognition that for a broad and fundamental principle like equality, no time limit is appropriate. There were no time limits on bills until the 18th Amendment, which was, for you that haven't memorized your Constitution, prohibition. And the ERA stands for a broad and fundamental principle, namely, government institutions cannot discriminate on the basis of sex. So the committee that voted to extend that timeline finds no less need to affirm that principle today than in 1978, and it finds no reason to believe this principle will lose its vitality in the years to come. So I always get this question, well, gosh, do we still need an ERA? Yeah. In fact, the late Justice Antonin Scalia, who was a constitutional originalist, concluded the 14th Amendment does not ban sex discrimination. The 14th Amendment affirmed the citizenship of all persons born in the US, but it guaranteed political representation only to male citizens, 21 years of age. In fact, yes, we had to have another amendment giving us the right to vote. This could give us a legitimate reason to push back if we go to the Supreme Court for the ERA. Now, this is a little bit of a lengthy slide, so I'm going to walk you through this because we constantly get this question, why do we need an ERA? I mean, we have a female vice president now, who, by the way, is still not represented equally in the Constitution. So one thing to think about, here's a few statistics. 70% of America's poor are women with children. Women make up half the workforce as of January 2020. And as we all know, we saw a she-session this past year. Women are twice as likely as men to retire in poverty. And we continue to see that sexual assault cases and domestic violence cases aren't prosecuted at the same level as even simple robberies in some courts. And according to the US Census Bureau, Of the 38.1 million people that are living in poverty in 2018, 56%, 21.4 million were women. In fact, beginning at age 5, the poverty rate is higher among women than men over the course of their lifetimes. So again, why do we need an ERA? Well, number one, it'll clarify the legal status of sex discrimination for the courts. Decisions are still very inconsistent, particularly because we don't get strict scrutiny. It would make sex a suspect classification the way race, religion, and national origin are. And we're going to talk about that a little bit more. And again, the only right guaranteed to women in the US Constitution is the right to vote. So let's talk about laws protecting women. So there's lots of laws in place that provide protection from discrimination for women in schools, in employment, during pregnancy, and in many other walks of life. However, these laws aren't comprehensive in their scope or application. Title VII of the Civil Rights Act is limited to workplaces with 15 or more employees, leaving women who work for small companies unprotected. Title IX, which addresses discrimination in education, only applies to institutions that receive federal funding, not to private schools. If the failure to reauthorize the Violence Against Women Act and the Me Too movement doesn't tell us that women need further protection under the law, I don't know what would move the needle. When the Violence Against Women Act was originally passed, it contained a provision allowing women to sue the accused in federal court. However, in a Supreme Court case in 2000, the court struck down the section of the Violence Against Women Act allowing women to sue, saying it exceeded the government's powers according to the Commerce Clause and according to the 14th Amendment. The states must provide the remedy, not the federal government. So we see that although Congress intended for women to obtain protection through the 14th Amendment, with the Violence Against Women Act, the court struck it down. Remember that Commerce Clause, you're going to hear it again. The ERA would provide a constitutional basis for claims of gender violence. Now, this is an old case, but it's an important case. In 2000, the Supreme Court struck down the provision of the Violence Against Women Act that enabled a college freshman, Christy Bronskala, to bring a case against the varsity football players who raped her. The Supreme Court held this kind of case didn't fall within the scope of the Commerce Clause of the Constitution. That, again, is what the Violence Against Women Act had been passed. And so there was no constitutional basis for the law. In 2005, the Supreme Court denied justice to Jessica Gonzalez, whose 3 daughters were killed when the police failed to enforce a court order of protection against her husband. Supreme Court held there was no constitutional basis for her claim because her order of protection was not a property right covered by the protection of the Due Process Clause. The ERA would help set more realistic legal standards for sex discrimination, including equal pay. So, 2011, Supreme Court ruled against Betty Dukes in the Walmart case. You might remember this, noting that even if statistics established a pattern of lower pay and slower promotion in every one of Walmart's 3,400 stores, wouldn't be enough to justify a class action by women who worked at Walmart, unless there was an express policy of discrimination. The lower salaries, lesser advancement by women across the country, resulting from discretionary manager employment decisions and the so-called Walmart way, which is a culture sadly infused with some sex discrimination, were found to be beyond the reach of the courts. This is an old case, 1982. Lola Cuba lost her case against Allstate Insurance Company. She and her colleagues were doing the exact same job, but her guaranteed minimum salary was $825 a week, while their guaranteed minimum salary was $1,000 a week. Allstate argues successfully that it wasn't discriminatory to pay Cuba less because she'd been earning less in her prior job than her male colleagues had earned in their prior jobs. Her lower prior salary was found to be by the court a factor other than sex, which is one of the exceptions in the Equal Pay Act and Title VII of the Civil Rights Act, which prohibit wage discrimination on the basis of sex. Now, the ERA would help ensure women can work safely while pregnant. Peggy Young, forced out of work by UPS during her pregnancy, UPS wasn't legally required to reassign her temporarily to a job that didn't require heavy lifting in the same way that UPS would be required to temporarily reassign a worker, say, who had a back injury. UPS even routinely offers its drivers who lose their license due to DUI temporary reassignment to jobs that don't involve driving. The ERA would require employers to make reasonable accommodations for pregnant women in the workplace. Here's one more case. Doris Garcia, pregnant, was fired by Chipotle for taking too many bathroom breaks and keeping a water bottle handy while she worked. She didn't have the same legal right to reasonable accommodations that people with disabilities have under the law. And I think we all remember this case when the ACA came into being. Hobby Lobby basically sued and said that providing birth control was against their religious freedom. And in the 2014 Hobby Lobby case, the Supreme Court upheld that employer had the right to deny women employees access to contraceptives through health insurance. The decision didn't even consider the negative impact of this policy on women's health and well-being, and it never used the word discrimination once. Religious rights receive strict scrutiny versus women's rights. So, finally, the ERA would establish the US as a global leader on women's rights, which we are not. As we know, we were all saddened when we heard about Ruth Bader Ginsburg's death in 2020. And, she was a fervent supporter of the ERA. Did you know there are 25 states that have an equal rights amendment in their constitution that provides either inclusive or partial equal rights? If I did a quiz right now, if I had this set up to do a poll, you'd probably be surprised which ones and tried to guess them. I know I was when I researched this. So the states with the red check mark are those states that have some type of ERA in their constitution. States guarantee equal rights on the basis of sex in various ways. So some, like Utah and Wyoming, entered the Union in the 1890s with constitutions that affirm equal rights for male and female citizens. Colorado and Hawaii amended their constitution in the 70s with almost identical language to the federal ERA. Others, like New Jersey and Florida, have language in their state constitution that implicitly or explicitly excludes both males and females in their affirmation of rights. Now, some states place certain restrictions on their equal rights guarantees. California specifies equal employment and education rights. Louisiana prohibits arbitrary and unreasonable sex discrimination. State constitutions, they can provide greater equal rights protection than the US Constitution does, assuming we have this in our Constitution. Ironically, and I'm sure you're looking at this map going, 3 states with state level equal rights have not ratified the ERA: Florida, Louisiana, and Utah. And what we know from seeing some of these state ERAs is that the success of these could be strong proof that a federal ERA would have real world impact. So you're listening to this and you're thinking, I don't understand why people are against the ERA. Well, there are basically 4 big objections that we hear to the ERA. This is the big one. It will enshrine abortion in the US Constitution. Nonsense. The repeated claim of opponents that the ERA would have the direct effect of requiring government to allow abortion on demand misrepresents existing federal and state laws and court decisions. They've been based primarily on due process and the right of privacy. In federal courts, including the Supreme Court, restrictive laws during the mid-20th century based on the constitutional principles of the right of privacy and due process, or how those laws were overthrown, not equal rights. And Roe v. Wade falls squarely in the middle of that line of court decisions, expanding the interpretation of the constitutional right of privacy of individuals to be protected against excessive governmental reach into certain personal areas in their lives. This is another big one. Well, the deadline's passed, the amendment is dead. As mentioned earlier, the three-state strategy was developed after the 92 ratification of the 27th Amendment. It was added to the Constitution 203 years after its 1789 passage by Congress. Little trivia here, after the 38th state approved the amendment, the Speaker of the House considered challenging the validity of the unusually long ratification process. But he changed his mind when members of Congress recognized how popular the amendment was. It's basically pay raises for Congress. So the archivist certified its ratification, and a day later, Congress passed a bill declaring the ratification valid, affirming political acceptance of the process. Now, Congress has done this before. They made a legislative endorsement of a ratification one other time. This is when it passed a joint resolution declaring that the 14th Amendment was duly ratified in 1868. So acceptance of the Madison Amendment's ratification period as sufficiently contemporaneous led some ERA advocates to say, maybe the ERA's existing 35 ratifications are still valid, and states could ratify the amendment even though the deadline has passed. They argued that the time limit on ERA ratification is open to change. Congress demonstrated this in 1978 when they extended the original deadline. And the precedence for the 14th and 15th Amendments shows that states' votes to retract ratifications have never been accepted as valid. And one of the guiding principles, and you're going to hear this a lot, of our legislative branch is that one Congress cannot bind or limit the power of later Congresses according to Article 5 in the Constitution. So they'd already changed the deadline once. And in doing so, Congress relied in part on where the deadline's location was. It's in the preamble, not in the body of the amendment, which I showed you at the very beginning. There's no legal barrier preventing Congress from eliminating the deadline altogether and doing so retroactively. No Supreme Court case has ever cast doubt on Congress's power with respect to the timing of ratification or suggested even that Congress lacks the power to extend or remove a ratification deadline after the fact. Now, what did Justice Antonin Scalia say? 14th Amendment does not protect women. It doesn't ban sex discrimination. It affirmed the citizenship of all persons born in the US, but it guaranteed political representation only to male citizens 21 years of age. In court case after court case, sex has been viewed only with intermediate and not strict scrutiny, like race, religion, and national origin. The Equal Protection Clause has really been interpreted, I should say, by SCOTUS to require proof that the employer intended to discriminate. So go in there and look at the employer's HR files and figure out where there's a document that says we intend to discriminate against women. Using the 14th Amendment gives women a 50-50 chance by proving discrimination based on sex, according to cases brought before the Supreme Court. Finally, well, we got enough laws on the books to protect women. You know, there's plenty. Like we have the Violence Against Women Act. Hasn't been renewed. To the Lilly Ledbetter Pay Act. I don't think that's been renewed. In fact, laws are overturned or not renewed by hostile or neglectful legislators. Without a bedrock foundation of equality in the US Constitution, plaintiffs cannot seek redress in the federal courts. Remember, the courts apply a lesser standard when it comes to discrimination against women than they do discrimination against African Americans, because African Americans have constitutional amendments directly related to them. Women do not enjoy that. To say that women enjoy equal justice under law right now is to ignore Supreme Court precedent. This is why back in the 70s, you had people like Strom Thurmond and Dwight Eisenhower and Richard Nixon, Barry Goldwater even, bedrock conservatives who supported the Equal Rights Amendment because it stands for something very fundamental. The ERA does not create new rights. It simply says those rights shall not be abridged by the government on the basis of sex. Now, the rest of the story, well, I think a lot of you on this presentation know this because you lived through it. So when the ERA was on a trajectory to be approved by enough states to amend the Constitution, the anti-ERA movement really went after Southern white women because the Southern states were the states where they thought the ERA would have the best chance of failing because they're the same states that didn't ratify the 19th Amendment for women's suffrage. So if you're a strategist for the anti-ERA group and you're going, where might we kill this thing? You're looking at places where the 19th Amendment wouldn't pass in 1920. And when they started talking to Southern white women, they really misrepresented the ERA. They realized that Southern white women had been politicized by the anti-feminist movement led by Phyllis Schlafly and others, and they really wanted to portray feminism and equality as a threat to traditional gender roles. And the beat still goes on. We get asked these questions quite a bit. How does the ERA protect the LGBTQIA community? So the application of laws prohibiting sex discrimination to situations of discrimination based on sexuality is currently evolving, even without an Equal Rights Amendment. In fact, today, I believe the Equality Act was passed by Congress, and that is heavily focused on LGBTQ rights. Discrimination on the basis of sexuality has not traditionally been treated by the courts as a form of sex-based discrimination. It's protected by an equal rights guarantee. Instead, the federal and state laws and court decisions have been rapidly evolving over the past several decades. They've legalized same-sex marriage, they've advanced LGBTQ rights based on equal protection and individual liberty principles. The other question we get is about it being intersectional. There is a feeling that the ERA became more about white feminism. And it's important to note that the ERA would ensure that gender equity is forever included in the US Constitution. Equality in pay, job opportunities, political structure, education, and healthcare. In particular, for women of color, women with disabilities, and the LGBTQIA community, it's going to remain elusive without a guarantee in the US Constitution. And some have asked whether the ERA really explicitly includes intersectional and inclusive language. The National Organization for Women affirms that the broad language of the text, which is equality of rights under the law shall not be abridged on account of sex, really lends itself to a more inclusive interpretation that supports the needs of marginalized communities. The ERA provides constitutional precedent for legal statutes that benefit women. If the ERA had been in place, employers like Hobby Lobby would not be able to single out women's health care and exclude birth control coverage from their employee-based plans. If you interpret this through an intersectional lens, the US Supreme Court decision disproportionately impacts low-income women. And this is the other question we hear. Well, why does it only seem that Democrats are supporting the ERA? And it's really sad because the Republicans were the first party to endorse the Equal Rights Amendment. When it passed in 1972 by both houses of Congress, it was bipartisan. Now, the Republican Party, which is about 93% male, sadly doesn't view the ERA as a priority. And since many religious groups oppose it because they believe it's harmful to the family unit and will enshrine abortion in the Constitution, sadly, quite a few Republicans are aligned with the goal, but not all. There are some Republicans, such as Senator Lisa Murkowski, who have been strong proponents of the bill. And I think our challenge as an alliance and your challenge as you go out and talk to different groups is to really dispel the misinformation around the ERA with our Republican colleagues and for those who really don't understand the bill. So here's where we are. I think this is a great map. You can see we've got our non-ratified states in the old Confederacy. We have our states that ratified after deadline. You can see Nevada, Illinois, and Virginia. And then we have the states that are wanting to take back the ratification. So that brings us to the lawsuits. Okay, so there are 3 current lawsuits. On December 18th, 2019, Alabama, Louisiana, Nebraska, Tennessee, and South Dakota filed a lawsuit against the National Archivist basically saying amendment isn't needed and would enable the removal of abortion restrictions. They also argued the deadline for ratification expired in 82 when only 35 states had signed off. 5 states, including South Dakota, that initially ratified the ERA have since rescinded their decisions. Now, on January 8th, 2020, as many of you will recall, the Justice Department's Office of Legal Counsel issued an opinion arguing the deadline set by Congress is binding and that the ERA is no longer pending before the states. Notably, that opinion actually rejected the conclusion of the 1977 Office of Legal Counsel opinion, which approved the earlier extension of the ERA's ratification deadline. So in response, the National Archives and Records Administration has said the archivist of the U.S., Daniel Fierro, will not certify Virginia's ratification or add the ERA to the Constitution until a federal court issues an order. Remember, Fierro had previously accepted the ratifications from both Nevada and Illinois. So I don't know, what would the courts have to say about this controversy? Well, way back in the 30s, the Supreme Court ruled that a question of whether an amendment has been ratified in a reasonable time period is a political question, best left in the hands of Congress, not the courts. In fact, constitutional law scholar Kathleen Sullivan agreed the timeline isn't binding. Take you back to Article 5 again. It provides no barriers to Congress changing its mind, either eliminating or extending the deadline. It's not a judicially, easy for me to say, reviewable decision. It's a political question, not something a court can come in and second guess. So if Congress were to pass a bill to remove the deadline, then that decision would be final and not reviewable by the courts. There's nothing in the Constitution that says that ratification must be synchronous, contemporaneous, or bounded with any particular time frame. Now, prior to Virginia's ratification, equal means equal, the Yellow Roses and Catherine Whitebrett sued the National Archivist. They filed this action to ensure that he properly recorded Virginia's ratification and the ERA's ratification and did not improperly remove prior ratifications by any state. Weeks after Virginia's ratification in 2020, state attorneys general in Virginia, Herring, Rowell, and Aaron Ford of Nevada filed suit to ensure that the ERA would be added to the Constitution. These 3 attorney generals argue that under Article 5, see, you keep hearing this, Article 5, sets out the process to amend a constitution. A proposed constitutional amendment automatically becomes part of the U.S. Constitution as soon as it's ratified by the legislatures of 3/4 of the states. Constitutional law scholars agree. Congress can modify the time limit because they set the time limit. What's really important to remember is that the time limit was not in the text of the ERA itself. It was part of a preamble. It was in the whereas and the wherefores before the text of the amendment. So the amendment is what the states vote on. The preamble is not ratified by the states. Again, Congress can set a deadline in something other than the text. Why can't Congress change it? In addition to the lawsuits, there have been 13 amici pro-ERA briefs. So amici is the friend of the courts, and they are go across the board from states to youth organizations, city mayors, the Montana governor, and U.S. businesses. 93 U.S. businesses signed on to an amici brief supporting the ERA. And these were a diverse group of businesses: Apple, Biogen, Bloomberg, Google, Goldman Sachs, Hershey Company, NFL, Pfizer, PepsiCo. So that's just a small handful. There were also 2 additional amici briefs against ratification of the ERA, and you can probably guess who one of them was. Our good friends, the Eagle Forum, which was Phyllis Schlafly's group, and the other organization is the Susan B. Anthony organization. And for those of you who don't know, Susan B. Anthony organization is a group that is very strongly anti-abortion. So they have also filed amici briefs in support of not ratifying. So where are we today? As I like to say, it's complicated, and I will try and simplify and tell you what we know. So equal means equal filed a written appeal to the Supreme Court. when the federal court in Boston dismissed the lawsuit for lack of standing. This is sort of unusual because they went straight to the Supreme Court versus going to another appeals court. But Supreme Court said, nope, we're not going to hear you. So then they filed their next appeal with the First U.S. District Court in Boston, and it's still waiting to be heard. Estimates from the ERA Coalition is that the Attorney General filing could be heard potentially this quarter in Washington, D.C. The National Coalition and Equal Means Equal have sent letters to the Biden-Harris administration requesting they instruct the archivist to publish the ERA in the first 100 days. They're also urging us and ad activists to send letters to the Biden-Harris administration asking them to urge Congress to remove the time limits. So, new legislation. I think most of you saw that in January of this year, bipartisan Senators Ben Cardin and Lisa Murkowski announced their Senate Joint Resolution 1, which we're very excited, first resolution of the 2021 Legislative House to remove the time limit. And then in the House of Representatives, Jackie Speer and Tom Breed, again, bipartisan, and 202 co-sponsors. And they're continuing to add them, reintroduced her joint resolution, which is now called HJ 17, House Joint Resolution 17. This year, in our North Carolina General Assembly, Representatives Julie Von Hafen, Susan Fisher, Carla Cunningham filed House Bill 8, and Senators Valerie Foushee, Natasha Marcus, and Natalie Murdoch filed Senate Bill 15, calling for ratification. Again, both bills got all Democrats signed on as co-sponsors, and both bills are currently sitting in the Rules Committee of both houses. So what next? Well, we're asking all of our members, our MailChimp subscribers, and anybody who's wanting to see this Constitution this amendment be added to the Constitution to urge Senator Burr and Tillis to vote yes on Senate Joint Resolution 1 to remove the deadline. They're actually considered the more moderate senators by the National ERA Coalition. Write the Biden-Harris administration. You can write the White House, urge Congress, say, come on, urge Congress to pass SJ1 and HJ17. Urge all congressional representatives in North Carolina to sign on to the congressional bills to remove the time limit. Educate North Carolina citizens on the importance of having full equality in the U.S. Constitution. We're going to begin outreach to Republican legislators in North Carolina and other groups on the importance of the ERA and continue working closely with the National Coalition. And, you know, one thing I want to just emphasize before I talk about what you can do as we wrap up. Our state continues to lag behind in many criteria, including women in government. The North Carolina Council for Women report on North Carolina women's political participation found while North Carolina women have been voting at slightly higher rates in recent years, their representation in elected offices decline. We make up 51% of our state's population, but the majority of North Carolina's political office holders at the state and federal levels remain male. At the current rate of change, it will be the year 2084 before women reach parity in our legislature. So we've got to depend on our male colleagues to work with us on equality. But here's some additional food for thought. Refusing to ratify the ERA in North Carolina can go beyond embarrassing a state. Non-ratification can pack a punch, just like ratification. Non-ratification can act almost like a dog whistle to uphold inequality, sort of a wink and a nod to, you know, keep it pressing on as possible. The fact that North Carolina didn't ratify the 19th Amendment until 1971, I mean, we labeled under that cultural influence and shadow of that non-ratification record for decades. And when the ERA passes, states rejecting it are going to feed an inequality mindset that may lay bare two Americas for women, ratified and unratified states. I'm glad we're pushing back against that scenario. We're really pushing for a 50-state strategy. And we do know that there are Republicans in the North Carolina General Assembly that do support the ERA. We just got to get it out of committee and onto the floor for a vote to see for sure. So what do? Again, write Senators Burr and Tillis. Ask your congressional representatives to vote yes on those resolutions. Write the Biden-Harris administration. Talk to your state legislators about why North Carolina needs to be the 39th state. Ask them to urge the Rules Committee to bring HB 15 and SB 8 to the floor for a vote. Talk to your friends and family. Every day, we go out and we talk to people. We wear our ERA yes buttons. Doctor asked me what I do, and they really think we've already got an ERA. We've done all the work. It's fine. Women are equal. Everything's hunky-dory. They don't know until something bad happens. We ask you to become a member of the organization. For those of you who are doing this with other groups like League of Women Voters, obviously you could change that. And we're asking counties, municipalities, organizations to pass a resolution in support of the ERA. So, in conclusion, 4.2 million women live in North Carolina and 0 women have equal rights.